starting off kind of through the whole life cycle of an employee, I like to jump in with the new hire packets. And surprisingly, the new hire packets here in California are becoming pretty complex. What you have to give a new hire when they're hired. There's required notices that you have to provide the employees, and I've got some of those listed here, and some recommended policies too, which I'll talk about here in a minute. But these are the required ones, and there's quite a bit of list here. So what I recommend is going through, getting these documents. The good thing is a lot of these are available on the internet, and to make that easier, I've got a QR code here. You can download our PDF document that's got a link to, I believe, all of those documents that are required, and take a look at those, download those, and put together a packet. And I like to work off of a checklist, have one packet so you don't have to compile this every time you hire somebody, less likely to have mistakes and things like that. Just as an example though, to this document, the notice to employee form, it's required under Labor Code section 2810.5. It's required for all non-exempt hourly employees. A lot of employers sometimes miss this document. It's an easy form to complete, something you can download from the Labor Commissioner's website, and it just takes some time to fill it out. Now, what I recommend is filling this out, again, in that packet you're putting together, fill it out as best as you can, as much as you can before you hire the employee so that you don't miss anything. So for example, the workers' comp section can be all completed, the name of the employer, an address of the employer, all those fields can be filled in. Obviously, the employee's name, the rate of pay, things like that, you're not going to be able to complete before they're actually hired. But it's going to be less likely to have any errors when your manager's filling it out or you're filling it out. So I recommend going through that and preparing those and getting those documents together. And again, it's a little bit of work, but once you get together the checklist and have those documents prepared, it's a good go-to package. And then just every year, take a look at any of those forms are updated. And the CRA will have those resources. I know I work with the CRA on updating those forms when a new form comes out too. Now, in the new hire packet, I do recommend having offer letters to employees. Now, is it legally required? It's not, but I recommend it for a number of reasons. You set out what the relationship is with the employee, and you can retain this at-will employment legal status with the employee to make it clear that they're going to be an at-will employee. And that means that they can quit at any time for no reason, and that you can fire them or terminate them for any time, for any reason or no reason at all. And that it's not creating any kind of contractual obligation with the employee to keep them for a certain amount of time or anything like that. Also have a job description. That's been coming up quite a bit, where we have employees now coming in. I don't know if it impacts restaurants a whole lot, but in the office environment, we're seeing some disputes come up about whether employees could work remotely. And you have to turn back to these job descriptions. Well, it's nice to be able to turn back to a job description and say, no, this was one of the essential functions of the job, that you actually come into the office and work. And we put that in your offer letter so that you're expected to do that and you need to come in. So it's good just to kind of put that out and clarify all those expectations for the employee. And then some legal issues here, the integration clause, if there are commission payments, those have to be set forth, confidentiality provisions. I don't think those issues are going to be huge in the restaurant setting, but something to think about. And then these choice of law provisions, again, I don't think you're going to need that in an offer letter in the restaurant setting, basically saying which law, which state law is going to apply to the employment agreement. But here in California, I don't recommend playing around with that a whole lot. This Labor Code section 925 basically requires employers that have employees in California to apply California law and California labor codes. So no, there aren't a whole lot of options on that front. Now, I do recommend having an employee handbook in place and have the employee acknowledge that receipt of the handbook. There are required employment policies that all employers, most employers, if you've got 5 or more employees, that you have to have. And the handbook is good to put that in place. Now, if you've got less than 25 employees, that handbook can be pretty simple, pared down. And then once you hit the 25 employee threshold, you have to start putting a lot of additional leave provisions into the handbook. But something to pay attention to. Now, arbitration agreements, as I mentioned, the U.S. Supreme Court just had a huge decision for California employers on the arbitration agreement. I think for a smaller employer, it's a toss-up whether you want to implement an arbitration agreement or not for your employees. It's something you should look at and consider, take a serious look at. And the arbitration agreement basically is an agreement with the employee that they're going to go to arbitration as opposed to court to resolve any legal disputes. And also schedule the sexual harassment training. Again, as a reminder, 2 hours for supervisors and 1 hour for all employees, and it must be completed within 6 months of a promotion or their hire date. And then for your non-exempt employees, I recommend some optional policies to put into place. The meal and rest break acknowledgement. More likely than not, you're going to see a claim for meal and rest breaks in California, having any type of employee here in California. So you might as well set this out explicitly and get their acknowledgement on what the policy is, and explain that policy throughout the year to employees too, and to managers, so there's no confusion over meal and rest breaks. And then a meal period waiver for shifts less than 6 hours.